All parties are again present. Deputy Smith, let's have the jurors, please.
We address the court on just an issue or two.
One issue, yes.
Your Honor, when I began my closing argument yesterday, there was an objection that Ms. Clark made with respect to improper vouching, but she misheard the testimony because I said, we believe the evidence shows an innocent man wrongly accused. And I realize that was a mistake on her part in objecting, and the transcript bore it out. However, I do have some concerns here with respect to improper vouching. I think it is improper to make an argument to the jury that Marcia and I are the ones with courage. That is classic improper vouching. I don't think a district attorney is allowed to say that in closing argument, and that's why we objected. I think it's improper for the district attorney to talk about, I prosecute police officers, so I know. The implication is there, A, don't worry, I'll take care of Mark Furman, I'll prosecute him. B, if Detective Van Adder is lying, don't worry, I would know that. I think that's improper vouching. I think it's improper to make an argument, everybody knows he's guilty. That's wrong. I don't think that that kind of argument is permissible. I think it's impermissible if they wanted to call an expert about domestic violence. That's one thing, but I think it's impermissible to say I know a lot about certain things with respect to domestic violence issues. And most importantly, there was this whole thing where they put up the video where, as was indicated, the court had ordered that that part be redacted and indicated deception. But worst of all, he then makes an argument that Dr. Lee, that infers to the jury or directly states that those shoe prints could have been left by those officers taking the blanket away, when Agent Bodziak specifically testified, agreeing with Dr. Lee, that they could not be. So that directly misstates the evidence. Finally, I would make this request, because this is the prosecution's rebuttal summation and we do not have a chance to get back up. And if there were misstatements of evidence in their opening closing arguments, we were able to get back up and read transcript and correct it. If we make an argument with respect to misstating the evidence, I would respectfully request that if the court is going to overrule it with the caveat, which I know is the thrust and substance of the court's ruling, the jury's recollection controls, because I think that's the fair and neutral way to do it. And so I make that request of the court, and I would also request the court caution counsel and that we have no more of this improper vouching, because I think it's an improper form of argument, and I'm talking about those specific matters.
All right. This matter is submitted. All right. Objection is noted. They're overruled. Let's have the jury, please.
There are a couple of photographs. There are a series of photographs of officers that the prosecution expects to show that I was just shown during this break, during Ms. Clark's presentation. And I have an objection I want to lodge.
What's your objection?
Well, I object. I think it's very similar to where we wanted to show the photographs of Mr. Simpson with the gloves on. That was a still. These are photographs of Risky and the various officers, Lang and the others, and we object. And with regard to the last two photographs that I was shown, it still has the KTLA Channel 5 logo on those. So I wanted to lodge my objection, having just seen these things at this point. I think it's analogous. I think it's what the court has said. I haven't seen these before, and I presume they would be pictures would put up there as she would be testifying about.
Is this four photograph?
No, I think they're one at a time, as I understand it. And you can see them if you care to.
They're still photographs of the
Mostly police officers. I think Mazzola's in there also. I went through the list.
I just told Mr. Cochran when he said he was going to object to this that the court overruled my objection. I had objected to the stills that they were going to use. They elected not to use them ultimately, but the court overruled it, saying the stills were proper. So I made this exhibit on that ruling.
Well, again, and of course, you see the last two with the KTLA seal, and
Well, the KTLA seal is irrelevant,
I
Counsel.
thought it was irrelevant, but you had us clear it up before. I thought that you had us cover that up. That was the issue.
That's at a time that where the source of it was not relevant to the issue.
All right.
All right.
Your Honor, one more
Noted.
objection I want to note for the record, and that is, I also think it was an improper argument that Mr. Simpson gave his bags to his lawyer on the way in. First of all, there's no facts in the record establishing that Mr. Kardashian was in the act of representing Mr. Simpson at that point in time, or that there was any attorney-client relationship at that point in time. I think it's a highly inflammatory and improper argument, and also does not accord with the known facts in the case. And another one I think they came perilously close to, with respect to the discussion of darkness at Bundy. And that is, we all were at the scene. Now, Mr. Darden wasn't. I appreciate that on the night that we did the jury view. And I have no objection to him citing from certain specific points in the record, but I would just like it noted, we all know what the lighting was like there, because we recreated the best we could, and then the prosecution chose not to take the jury on a nighttime jury view. It was their decision. And it seems to me that in terms of good faith arguments based on what is knowledge of all the parties here, that I think they have to be very, very careful in terms of raising inferences to the jury about what could be seen and couldn't be seen in light of what we know.
Well, what we know is from a recreation counsel, the testimony of the witnesses as to approaching that walkway under conditions of darkness on June the 12th and June the 13th are in the record, and it's a fair inference. The argument's concluded, counsel.
I understand that. I'm just saying that
Sit down.
that was perilously close.
That's a fair inference that can be drawn from the record. Also, I'm going to admonish counsel on both sides not to make any gestures, head shaking, grimaces, or any other responses to a counsel's argument. I've seen it on both sides, and if I see it again, I'm going to stop in front of the jury, and I'm going to upbraid you in front of the jury. Let's have the jurors. Both. Ladies and gentlemen, please be seated. Record should reflect that we've been rejoined by all the members of our jury panel. Just want to make sure we're safe. Mr. Darden, you may continue.
Thank you, Your Honor. Good morning again. I'm just about done, because I'm very anxious to get this case to you so that you can so that you can resolve it, so that we can have some closure as it relates to this case. One of the things that was mentioned the other day was something about Robert Heitstra, and you remember Mr. Heitstra. He was the witness who had the laminated letter from Ethel Bailey saying that he was going to be an important witness for the defense. And much ado was made about Mr. Heitstra and why we didn't call him, we the prosecution didn't call him, and I think it was suggested that we didn't call him because he didn't fit our timeline. Well, they don't know what we're thinking. They can't read our minds. They called Robert Heitstra in the defense case. They don't know whether or not we were going to call him in the rebuttal case. They don't know that. Robert Heitstra is a very important witness. They called him. Fine. As long as you heard the testimony, that's all that mattered. He testified that he left his house around 10:15, right? Isn't that what he testified to? He said he saw the clock in his apartment, as I recall. He left with his dogs. He left on a walk. He walked around the block, halfway around the block. And as he approached Bundy, he heard these dogs barking. And he told you that it was around 10:30. And I asked him some questions. I asked him, did you look at your watch when you first heard those dogs barking? No. All he could do was give you an approximation as to what time he heard those dogs barking. And in his best estimate, his best guess was about 10:30. And so he says he heard Cato, the dog, bark around 10:30, and that he changed directions and walked down that alleyway. He walked down the alley on the opposite side of Bundy. That is the side opposite from Nicole's condo. He walked down the alley, and as he walked down the alley, he heard someone yell, "Hey, hey, hey." And he stopped, and he paused. And he told you that hey, hey, hey voice sounded to him to be the voice of a young man. And he also told you that he heard the voice of another man, an older man perhaps, with a heavier voice. Remember that? Remember that? And he continued to walk down that alleyway, and when he got down to Dorothy, he looked west toward Bundy, and what did he see? What did he tell you he saw? He saw a vehicle coming east from the direction of the alleyway that ran up behind Nicole Brown's condo. It was his vehicle. It was the defendant. I asked Mr. Heitstra, what color was that vehicle? He said it was white, just like the defendant's vehicle. I asked him if the vehicle had tinted windows. He said it did. You look at the pictures of the defendant's Bronco, tinted windows. Yesterday, someone stood up here and said to you, Heitstra never said anything about Bronco. He said a Jeep or a van. I asked Mr. Heitstra about the vehicle he saw. And he told you right here on the witness stand that the vehicle he saw was a Blazer or a Bronco. I asked him specifically. I asked him that specifically at pages 36,339 and 36,471. And at 36339, he told you, he testified. He was a defense witness. He testified that the vehicle he saw could have been a Bronco. He didn't look at his watch. He didn't look to see what time it was when he first saw that Bronco. And what did that Bronco do?
Counsel, ladies and gentlemen, you've heard all the evidence. As I indicated to you when we started these arguments, counsel may argue to the evidence and draw reasonable inferences from that evidence. However, you are the exclusive judges as to what facts exist from the evidence in this case. Proceed, counsel.
Thank you, Your Honor. And that's true. But this is their witness. This is Robert Heitstra. That's what he testified to here in the transcript. It could have been a Bronco. It could have been a Bronco. That's what he said. Chevy, Blazer, or a Bronco. Remember that? And I asked him a question. Okay, well, you're saying Chevy Blazer or Bronco. I asked him a question at page 36, 471. I asked him, Mr. Hydra, a Chevy Blazer and a Ford Bronco looks very much alike to you, doesn't it? And his answer was, yeah, they look alike. Certainly, from a distance. I would suggest to you that the vehicle Hydra saw leaving Bundy that night was a white Bronco. It's a white Bronco that has all that blood in it. It's the white Bronco that's parked askew at the defendant's house. This is their witness. And I said it the other day, and I'll say it again today, I don't care what the time is. It doesn't matter. It doesn't matter at all. He didn't look at his watch the time that he saw that Bronco or that Blazer. And I asked him about that, and I asked him if he looked at his watch, and he told us he didn't look at his watch. And then I asked him how long it would take to get from Bundy to the defendant's house, because as you recall, Mr. Heidstra watched cars, detailed cars, for the Salingers, the people that lived directly next door to the defendant's property. And I asked him at page 36, 413, counsel, at line 3, I asked him, Mr. Heidstra, would they have enough time to drive to 360 North Rockingham and arrive by 10:52? His answer, yes, you could do it. Yes, sure. And I went on to ask him, you could arrive there by 10:45, correct? Line 14, page 36413. And at line 15 on that same page, his answer was right. Yes. They want you to believe that Cato Kalin heard the thumps at 10:45, and Ms. Clark will explain to you how it is that we extrapolate some of the facts, some of the hard facts in this case, facts that can't be disputed when you consider all the testimony and facts that help establish what time Cato Kalin actually heard those thumps. But it doesn't matter. If Kalin says 10:45 and that's his best estimate, Mr. Heister says, hey, there's enough time to drive that Bronco from this death scene, this scene of murder, to the defendant's house. And finally, we get to gloves. Finally, we come around full circle once again to the issue of gloves. And I watched one of the defense lawyers stand up here and pull a watch cap over their head and ask you what they looked like, if it changed their appearance. Well, you know, in a lighted courtroom at the intersection of Temple and Bundy, it probably doesn't change his appearance at all. Especially after somebody's been standing up in front of you for 2-3 hours. But the issue is, would it change his appearance? Would it affect one's ability to recognize him if it was 10 o'clock at night? How about 10:03? Will it affect your ability to recognize him in the dark? And what if he had on dark cotton sweats? And what if it was dark out there in front of that condo the way Officer Risky described? Or what if he had a big knife? These little demonstrations that we saw. And then we saw one of the lawyers struggle with a pair of gloves. These are your gloves. These gloves are size small. Defendant's gloves were extra large. We heard so much about the scriptures. I'm not even going to read it. Just read Proverbs 6 one day when this is all over. Now, if I'm the messenger, you know, I've delivered the message as best as I could. And the message is that he killed these two people. And that's what the evidence dictates. You know, they mess around with our science evidence and stuff and try to cause you to lose confidence in that evidence, but Marcia Clark will go back and go over some of the points we think you might be interested in hearing about to sort of straighten that out. But I know that you're going to do a good job when you go into the jury room. All I could ever ask from you, and all that I ask from you today, is that you try and be as objective as you possibly can be. That you not allow any passion or emotion or any bias, any of that human feeling, those human feelings we all have, to interfere with the decision you have to make. When I stood before you back in January, I said there were many victims in this case. And there are many interests involved in this case. It's an important case to O.J. Simpson, and it's an important case to the victims and their families. We just want you to be fair. I just want you to do the right thing. That means the right thing under the law. We believe we've proven this case beyond a reasonable doubt. And it's unfortunate. It's unfortunate what jealousy does to you. It's unfortunate that obsession. It's unfortunate that obsession can do these things to you. It is unfortunate that 2 innocent people are dead because they got in this man's way. That's the message we wanted to deliver. And I'm the messenger, and I'm proud to have delivered it. I thank you for your verdict in advance in the event I don't get a chance to talk to you then. All of us owe you a debt of gratitude. God bless you.
Ms. Clark.
Good morning. How are you? I'm not allowed to ask you that, I just realized. Excuse me. I know you're tired of hearing us talk. I'm going to get right into the evidence because I want to go through what they said. I want to show you how the evidence corrects that. And I want to talk to you about logic. I want to talk to you about what makes sense, okay? Because you've been hearing a lot of stuff that really makes no sense. You've been hearing lawyers spin stories and spin yarns for you with no evidence to it. Not only does it have no evidence, but it has no logic. And in that specifically, I'm talking about this story about Mark Furman swiping a bloody glove inside the Bronco. Well, that's a story. That's an interesting story, but it has no substance. Not only does it have no proof to it, but it also has no logic to it, and I'll show you why. And that's what I want to talk to you about now, logic, what makes sense. In this case, we have seen what the defense has done, and it's been a very contorted, very inconsistent thing. I'm going to point out the inconsistencies to you. But basically, they have jumped from we are stupid bumblers or we are brilliant conspirators. And he includes us in this. And I find that particularly painful, ladies and gentlemen, particularly painful, because I've been doing this a lot of years. I didn't start here. I started on that side of counsel table. I was a defense attorney. I know what the ethical obligations are of a prosecutor. I took a cut in pay to join this office because I believe in this job. I believe in doing it fairly and doing it right. And I like the luxury of being a prosecutor because I have the luxury on any case of going to the judge and saying, guess what, Your Honor, dismiss it. It's not here. Ladies and gentlemen, I can come to you and I can say, don't convict. It's not here. I have that right. I have that luxury. This job gives me that luxury. It doesn't give me a lot of money, but it gives me that luxury. I can get up in the morning and look at myself in the mirror and say, I tell you the truth. I will never ask for a conviction unless I should, unless the law says I must, unless he is proven guilty beyond a reasonable doubt on credible evidence that you can trust, that you can rely on. I can never do it otherwise. That's my obligation. And that's why I'm standing here before you today, because we have proven it to you, ladies and gentlemen. If I thought for 1 minute there was a conspiracy,
Be seated. Ladies and gentlemen, would you have a seat at your case? All right, records to reflect the jury is withdrawn from the courtroom. Ms. Clark, the last comment that you made, if I thought for a minute there was a conspiracy,
I would get to finish it. It would be my obligation to dismiss this case.
we're close here, counsel.
Your Honor, in view of the...
This has been
Wait.
highly I'm sorry.
Sit down.
No, sorry.
You're close, Ms. Clark. I realize it's not a complete thought, but what you can't argue is what the evidence shows. You can argue ethical obligations that prosecutors have. I'm just cautioning you that you're close here. You're
Okay.
close to the line.
Okay.
You're not over it yet.
Thank you, Your Honor. I was...
Mr. Scheck,
Excuse me, may I just ask for one point of clarification? The thought as I completed it is acceptable, is it not?
it is.
All right.
But the eyes, every time the eyes get in there,
Yes. The only... Let me just mention this. I have never had a defense attorney make an argument like Mr. Cochran made, nor have I ever seen a defense attorney get up and ask for jury nullification in this way. But when they do...
it was very artfully phrased.
I'll reserve comment. But what I'm saying, Your Honor, is that when a defense attorney does take the gloves off that way, hit below the belt the way Mr. Cochran does, the law permits us to argue our ethical obligations. The Court's aware of that. Under People v. Bahia, under U.S. v. Wade, we have the right then to argue what our obligations are. I get to tell the jury the truth, that I have a luxury they don't have, a luxury I didn't have until I joined this office. They have to represent guilty people and stand up before the jury and say it hasn't been proven, no matter how well it has been proven. I
I'm
don't
sorry,
have
counsel,
to do
you're
that.
objecting to her argument to the court?
Yes, I object. Be quiet, please. I objected to that. I didn't have a right to do that.
Anyway, these are not remarks that I make to the jury, but when counsel takes off the gloves, makes personal attacks the way he has, saying basically that we're criminals, then we have the right, under the law, to correct that misimpression and to tell the jury we have ethical obligations that prevent us from pursuing a prosecution unless we believe 100%.
There's the problem.
Okay,
Unless you believe the evidence shows it.
right,
You have to be clear. You cannot infer that you have personal knowledge beyond the state of the evidence.
right. Agreed. No question. I wouldn't do that.
Mr. Scheck,
Your Honor, they already have. They've gone over the line. Now, as the court noted, the argument yesterday, and it's one that these prosecutors have to live with, is that they put Mark Fruman on the witness stand. He testified in a way about, Mr. Cochran accurately cited the record. He read from it, talking about how he went through all this terrible personal anguish and all these outside issues were raised, and he was presented as a totally credible witness. Now these prosecutors have to get up in front of the jury and say he's a racist and a liar. They have to do that because that's what happened. The jury is allowed to consider the fact that they were plainly taken by surprise by the perjury of their own witness. They also have a right to consider the fact that other officers probably knew these facts and never came forward. That's fair argument and fair comment on the evidence. What's unfair argument and unfair comment and clear law is for a prosecutor to stand up and say that I prosecute police officers, Marcia and I are the ones with courage, and then to go on now and say that she used to be a defense lawyer and now she's a prosecutor and she has the luxury of dismissing cases if the evidence is not there and coming forward if she thought something was exculpatory, etc., and then vouching personally for the reliability of the evidence is a highly, highly improper form of argument in this state, every state. They've gone way over the line, and it's really got to stop. It's really got to stop. And I don't like to sit here and constantly say objection, 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 objection to improper forms of argument, and the court is being patient and controlled in terms of overruling it, but this is way, way over the line. I mean, I've been teaching law for 18 years, And I never heard this kind of stuff. And I dare say that people, it's amazing. It's amazing. They cannot say it. And what's particularly galling is that they're saying it when they are the ones that have to live with the fact that one of their principal witnesses perjured himself after they put him on. It hurts. But Mr. Cochran's comments with respect to that are fair on the evidence. And trying to vouch in this fashion is improper rebuttal, an improper form of argument, period.
What I heard also was you can't trust the messengers and you can't trust the message.
Well, those were...
And wait.
Yes,
And Mr. Darden clearly cast himself as a messenger in his argument. That was a clear shot at the integrity of counsel on this side, and they're entitled to respond.
Wait a second. I think that's incorrect, and please hear me on it. Mr. Cochran's arguments yesterday, Mr. Darden got up and said, I'm just the messenger sending you evidence. Mr. Cochran got up and said, the messengers in this case are the witnesses. The messengers are Mark Furman, oh, he did, and Van Adder. He talked about these messengers being deceivers. And that is the argument. Now, I don't see how the court can allow this kind of vouching if you are inferring that there's some kind of, metaphor crossover here. Mr. Cochran has a perfect right, it is a total fair comment on the evidence, to talk about these prosecution witnesses as messengers. If Mr. Darden chooses to cast himself as a messenger too, well, that's fine. But I didn't interpret that as a comment on Mr. Darden. It was a turn of phrase, and he specifically talked about these witnesses. And to the extent that Mr. Cochran is pointing out that Mark Furman was put up there first as a credible witness, and now they have to admit that he's a liar as they did, and they're distancing themselves, that's fair comment. What's unfair comment is for them to get up here and in this fashion vouch for every other witness and every other piece of evidence in a highly improper form. They've gone way over the line. Way over the line.
Cite me a case, counsel, California law dealing with comments of counsel.
Well, Your Honor, you have discretion here, and we all know the basic principles in terms of the American Bar Association.
I have cautioned them, counsel.
Rules, I'm sorry?
Well, the California State Bar is a bar that is unto itself and has its own rules, counsel.
I've read the Gionis case, and I understand that they can say things that you can't say in other jurisdictions about smoke screens and the rest of it. But in this jurisdiction and in every other jurisdiction, there are rules about vouching. And they've gone over that line.
Well, here's the
We want
problem.
instruction. I think the court,
No,
the
counsel.
court should at least give a balanced instruction at this point to the jury that it is not the prosecutor's personal views or personalities or anything else about the evidence that govern. It is their view of the evidence, and they should
Right.
take that. I think we are entitled to an instruction like that at this point.
What a prosecutor may not do is a prosecutor may not express personal opinion or belief in the defendant's guilt where there is some substantial danger that the jurors will interpret this as being based upon information beyond the evidence produced at trial. I have not heard that yet.
That's a different improper form of argument. And I think actually Mr. Darden was pretty close to that when he was talking about everybody knows, and yesterday he was saying things like, he's a murderer. I think he actually went over that line, but let's put that aside. What I'm most
Are
concerned
you
about
saying
now...
that there is a substantial danger that when a prosecutor stands up and says that the defendant accused of murder is a murderer, that goes over the line?
No, no, no. I'm saying that you just read in terms of a prosecutor's obligation. He's got to say things like, the evidence shows we submit. And I think that in terms of rhetoric, he went over that line. But let's put that aside. What I'm most concerned about, and the court, frankly, is not addressing here, the court can't be seriously suggesting that a form of argument that says, we are courageous, we know our ethical obligations, we are telling you that this evidence is correct. If I thought there was a conspiracy, I would come forward and tell you all that Everything they've been doing this morning is an improper form of argument, it's improper vouching, and, Your Honor, I think you know it. And I think that we have to have an instruction here.
You're close here, Mr. Scheck.
Well, I've made my point, Your Honor.
Thank you. All right, Ms. Clark, I'm cautioning you, though.
I understand that.
People versus Bain, 5 Cal 3rd, 839. The court's comments at 848.
I'm aware.
You're cautioned.
Yes, Your Honor. I'm going
I don't want to hear any more ayes.
Right. You won't. I'm ready. I'm ready to no more ayes.
Deputy Smith? Ladies and gentlemen, please be seated. Let the record reflect that we've been rejoined by all the members of our jury panel. Ladies and gentlemen, as I indicated to you earlier, argument is a very important part of the case. It's the opportunity of the lawyers to actually bring everything together in a logical and coherent way. And I indicated to you that the lawyers may argue the evidence that is in the record and draw from that evidence reasonable inferences for you to consider. Those are the guidelines. I needed to discuss a few matters out of your presence with the lawyers. We're ready to proceed. Ms. Clark.
Thank you, Ron. Once again, so as I was saying, if there is evidence of a conspiracy, it would be my obligation to dismiss. Pure and simple. And I can go on to the next case.
Overruled.
But there isn't. And in this case, we have,
Overruled.
I'm going to finish what I have to say to you, and I'm going to do it as quickly as I can. Okay. What we have here is logic and evidence and common sense, which when you weave them all together, you can see what the truth is. You can see what's really happening here. I'm going to start with a very simple example, and that is the arguments that were made to you about the notification of to the coroner. You might remember the counsel made a big deal about the fact that the coroner wasn't called till late. And Mr. Cochran has repeatedly referred to the rush to judgment. Now let me address that with you for a second, the rush to judgment. The argument has been made that when they went to Rockingham, what they really wanted to do was make an arrest, right? The rush to judgment. They had it in mind that they were going to go there and arrest him, and he was a suspect, and there was a reference made to a remark made by Mr. Van Adder in January or February of this year that seemed to contradict what he was telling you about his state of mind. Now, I don't know about you folks, but what I do when I have a doubt, when I wonder about what somebody really means, whether I can believe them, I look what they do. Look what they do. Like we were all taught as kids, actions speak louder than words. Yes, they do.
Yes, they do. People can say things. We all know they can. But let's see what they do. Now, what did they do? Okay, let's look back at the evidence that is not contested, the evidence that stands unrefuted. They were out at Bundy. Commander Bushy told the initial detectives, get on out there, go and make notification at Rockingham. You know that would be a problem for somebody who's famous, because if the media finds out it's all over the place, that's a very painful thing. And Commander Bushy sure doesn't want it to happen on his watch that would happen in this case. So he told them, go out there. That's what he told you. Did they? No. They weren't sure if they were going to keep the case. I'm weaving the testimony for you together without reading from the transcript. You have it, though. I'm not going to bore you. But Detective Phillips did say, we weren't sure if we were going to keep the case if we had the resources. That was a real big problem with this case, because they only had, like, I think he said 4 or 6 detectives in homicide over in West L.A. So they thought that it might be taken over by Robbery Homicide Division downtown that has many, many more detectives and more resources. Before they act, before they move to make notification, which is an important thing to do in a homicide case, your first contact with next of kin is to go and make the notification, make that contact, establish that rapport. And there might be some information that you can get from the next of kin or the person you notify that could be very helpful to solving the case. The person could be a witness, okay? Now, especially in this case where they have children in common, he might know who she's dating or not, because, you know, they're divorced, but they still have to have contact. He might know something. It's an important first contact for them to make. So whoever is the handling detective is the one that's supposed to go. This is the testimony you've already heard. I'm not telling you anything new. So they waited. They waited until they found out if Robbery Homicide was going to take the case, and sure enough, they did. That's what happened. Van Adder and Lang came out there, and I guess they showed up around 4:30, I think it was. All right. So they were standing out there waiting for quite a long time. Now, when Van Adder and Lang got there, or in between, I think, when it was finally assigned to Robbery Homicide, Commander Bushy spoke to them again and said, go to Rockingham. You know, how many times do I have to say this? Go and do it. So then finally, they still didn't go and do it. They still didn't run out there, okay? That was, I can't remember, I think he said it was around the time, he couldn't be specific about the time, that's right. But he said he knew that Van Adder was there, that Robbery Homicide had taken over the case. Now, Van Adder didn't get there, I think, till 4 or so. The record will refresh your memory. I can't remember exactly, and I'm not trying to tell you I am. But it was that time. Even then, they didn't go immediately. It was, I think, about 5 o'clock when they finally went to Rockingham. Finally went there. Now, think about this. There were a lot of questions asked about why couldn't you have sent a rookie to go and make notification? Okay, now you know that doesn't make sense. If notification is an important thing, first of all, it has to be handled delicately, sensitively, by people who have done this before, many times before. Homicide detectives, it's one of the saddest parts of their job. They have to make these notifications every day, but they know how, and they know how to deal with it. Bless you. So they're going to go and do it themselves. It's an important contact. That's their job. That's their duty. Okay? So they can't send a rookie out to do it. But what should they do? Think about this now. If it is their intent to go out to Rockingham, make an arrest, because he's a suspect, there are certain things they should have done. Number one thing is you take backup. You don't go by yourself. You take backup. You take a couple of squad cars, you make notification downtown, hey, we're going to arrest, and this is an important suspect, and, you know, this could be a big media event. You make plans, you make arrangements. They did nothing. Zip. They went out there and they took just the 4 detectives in their 2 cars. They went over to Rockingham. That's all they did. What else should they have done? Ask yourself. If they know
Excuse me,
that
counsel. Overruled. They may argue reasonable inference from the evidence that is in the record. And has counsel have a seat.
your common sense will tell you I'm not misleading you. This makes sense. I'm talking logic. I'm also talking logic based on what the witnesses have told you. You know it when you hear it. Now, what else should they have done? If they're going to go make an arrest, that's going to take some time. They could really get wrapped up. They could do questioning. They could take downtown. They could, the things that you know happen when someone gets arrested. So, if they know they're going to take a long time, they have a crime scene that has to be processed, they have 2 dead people lying out there, and all that evidence around, what would they do? They would go to somebody who's going to stay at the crime scene, and they would say, Call the coroner. We're going to be gone a while. Call the criminalist. We're going to be gone a while. We need you to get this evidence collected, and we won't be here because we're going to make an arrest. Did they do any of that? No. Now, what the evidence has shown is, and what they've testified to, and what their actions tell you is true, they expected to come right back. 2 of them would stay with Mr. Simpson, taking care of him, taking him to the station to get his children, making the arrangements, and 2 would go back to Bundy and handle the crime scene. And their actions totally support that. If they expected to be gone a long time, they wouldn't all forego. Or they would tell someone else, take care of business for us, we're going to be gone. They didn't do that. What their actions tell you is, we're coming right back. It doesn't really matter if somebody isn't taking care of business and calling the coroner and calling the criminalist. Logic. Logic. Look at their actions. Look at their actions. You don't trust the words? Look at what they do. That's what they did. Right now, an argument was made to you about standing the Constitution on its head. And that's because I said, look, why don't they call these witnesses? There are witnesses they should logically call. Now, I'm talking about logic. I'm talking about reason. I'm talking about what do you expect? What would you like to hear? These are questions you're entitled to have answered. These are questions that you should consider. These are fair and reasonable questions, and these are questions that do not stand the Constitution on its head. I told you when I first argued to you in the beginning of all these long arguments that they would be telling you many, many times, the defense, we don't have to prove anything. If you heard it once, you heard it 50 times. They did. That's what they said. And that's right. They don't. But when they do, but when they try to, then you have to evaluate their evidence the same as ours. There's no difference. The jury instructions govern all the witnesses. And so you look, what is the quality of evidence that I've been given by the defense? What witnesses have they called? What logical witnesses that you would expect to be called weren't called? That all tells you something. It's legitimate for you to consider it. You must consider it because, as I showed you in the jury instruction beyond a reasonable doubt, you must consider all of the evidence. That means everything that was done and not done. And here's an example. Thanoparatus. Remember that? That was the nurse. He drew the blood. That was their witness. Now, he was their witness because he was the cornerstone of their case. Very important to make you believe that there is missing blood. But then, now I think defense counsel made some reference to that, the notion that Hank Goldberg, secretly went out and interviewed him. What's secret? You know, if you have a question about this, ask the judge. No attorney for either side is required to give notification to the other side, oh, I'm going to go interview my witness. That makes sense, doesn't it? They don't notify us. We don't notify them. We talk to them. We give them evidence of it. We give them a statement. Here, we talked to this guy. Here's the statement. That's what we do. Hank Goldberg went and talked to him. Mr. Parada said, no, I didn't measure. No, I didn't look. And I realized I was wrong. I was trying to be very precise. Okay? Now, here's the syringe. You're going to have this back there. You look at it. And what he said was, I turned it over. I had it turned over, and I couldn't see the numbers. And you'll see when you look at the numbers and all these little lines, unless you're sitting there like this, you're not going to be able to measure precisely how much you've got in there. But if you have it turned over, you're really not going to know. Okay? But beyond all of that, it just kind of makes sense. If no one tells you you must take this much blood, you're not going to look to take that much blood. You're going to take enough. You take enough for sampling, for testing, and that's what they did. Now, thanoparatus is not truly a real important part of our case because we prove to you in many different ways the integrity of the evidence. I'm going to get into the blood evidence and why it's proven to have integrity in just a little bit. Let me start with hair and fiber, though. Jonathan, do we have those? Thank you. All right, now, there were a number of misstatements made to you yesterday by Mr. Scheck concerning the hair and fiber evidence. I'm going to go into just a couple of them. And one thing that Mr. Scheck said was that Mr. Diedrich and Dr. Lee agreed that hair and fiber association was weak association. Well, here's what Dr. Lee testified to, page 43,168. Question posed to Dr. Lee. Do you agree with the following statement? While it is difficult to make absolute individualizations in these areas, the trace analyst can make identifications with a high degree of certainty and can often establish partial individuality of a specimen with confidence based on experience and analytical results. Answer. I would say 80 to 90% that statement correct. They forgot one thing, depends on samples. Not all the sample you can reach that degree of certainty. Some of the samples, yes, you can. In other words, it's a very good, what he said, can establish partial individuality with confidence. In other words, it's a very strong method of association. Now I'm going to show you the pictures, and you'll see why they make that strong statement about it. You may remember, we showed you this during the trial. This is people's 480. Remember this? His known head hairs on the top row, and then the hairs from the knit cap at the bottom row. And you look at them, and you compare, and you see. Your eyes tell you. You don't need to look at x-rays. You don't need to look at autorads. These were the hairs in the knit cap found at the feet of Ron Goldman. This is testimony that was unrefuted. No defense expert came in to tell you this wasn't so. And people's 481. Again, the defendant's known hairs. Hairs taken from the knit cap. Hair from Ron Goldman's shirt. You can see this. Mr. Scheck also told you that the blue-black cotton fibers that were found on Ron Goldman's shirt, on the Rockingham glove, and on the defendant's socks were very common. That's what he argued to you yesterday. That is not what the testimony said. Let me read to you what Doug Diedrich told you about this. Page 35,093. Question. Now, you saw a lot of fibers in this case, correct? Answer. A lot, yes. Question. Was there something unusual about these particular blue-black cotton fibers that drew your attention or made you pay particular attention to them? Answer. Yes. Well, cotton fibers themselves, they are common. There is a lot of cotton fibers out there. What gives cotton fibers significance is that when you add color to them in a specific way, some you see more may be less likely than others. These are actually, it is a real dark blue. It looks black, but in some areas the dye was not absorbed the same, and this may be where the yarns are attached to the fabric. The same thing appeared also on the fibers that were recovered from Ron Goldman's shirt, the bluish area, also present here. It was recovered from the defendant's socks. The bluish area here is starting to show. Some of these areas can better be shown using instrumental techniques with color because the eyeball sees this as a shade of blue, this as a shade of blue, and so forth. And then he goes into all of the methods that he used to examine these blue-black cotton fibers to determine that they did in fact share the same microscopic characteristics. And I was going to read it all to you, but it's just too long. But there's a lot of tests that he used. And it had to do with the color, and it had to do with the dye, and it had to do with the appearance. And if you need to have it read back, please do, but you also have a picture. And if you don't want to read it, you just see it. Equals 487.
Can you just show that briefly to council? All right, thank you.
And you can look at these fibers. Look, from the Rockingham glove, Ron Golden's shirt, there's Bennett's socks. These are things you can see. Now, there was also some discussion about the defendant having dandruff, if you recall. And it was told to you that the defendant always had dandruff in the off-season. That is not what the testimony showed. Here's what the testimony actually showed about that. Page 37,441. Question. And sometimes in the summer, when you saw him take care of his hair, he would have dandruff, and sometimes he would not. Answer, that's correct. That was his barber. The other interesting thing that she told us is that unless you brush the hair vigorously, the dandruff does not come off. So I asked her, if you just brush his hair, the dandruff doesn't come off? Answer, right. Which means if you don't brush or comb the hair and it just falls off by itself, the dandruff doesn't come off. If you don't do anything to the hair, I guess it will just stay there. Now, the hairs in the cap did not have dandruff. And the defense wants you to believe it couldn't be his hair because he has dandruff. That is not what the testimony showed. That is not what the evidence showed. The evidence showed sometimes he does, sometimes he doesn't, but actually, even if he did, it wouldn't come off in the knit cap because you had to brush vigorously to get it out so that it would show. So what you have in the knit cap are his hairs, the naturally shed hairs that are his, because he wore the hat.
Whole room.
You have jury instructions. I spoke to you a little bit about them before. There was one I didn't talk to you about. I want to mention now because I'm going to talk a little bit about Dr. Baden and what he testified to. And that instruction is 2.80. 2.80. Do you have that on the bench, Your Honor? 2.80? Wait, I have it. Thank you. You have a few instructions. It tells you about expert testimony, and this can be really helpful to you because I think I'm not alone in getting a little bit intimidated by experts. They know. They have doctor in front of their names, and what do I know? But you shouldn't be. You shouldn't be. You are allowed to evaluate the opinion of a doctor, and if it doesn't make sense, you can say, you don't make sense, I don't believe you. It doesn't matter if they have doctor or PhD before or after their name. You get to evaluate it because if it's not logical, if it doesn't make sense, it doesn't matter what their title is. And that's basically what the instruction says. 2.80, you'll have it back there. And it says the following. You are not bound to accept an expert opinion as conclusive, but should give to it the weight to which you find it to be entitled. You may disregard any such opinion if you find it to be unreasonable. Okay? So what that tells you is, don't be intimidated by the title. You know what makes sense. And if you find it to be unreasonable, toss it. Okay? Dr. Baden told you some things that were that made absolutely no sense. They defy the laws of gravity. What am I talking about? I'm not going to drag all the pictures out here right now. You'll have them back there if you want to verify this. One thing that he said that I just couldn't believe I was hearing is that the jugular vein cut was the one that caused the blood on Ron Goldman's pants. Now, think about this. This is jumping blood. Because there isn't a big, then it should be jumping down the shirt, right? Logic tells you that if he's bleeding from the neck It's going to drip down his shirt and then get to his pants. You look at his shirt. It's not there. The front of the shirt is not blood-soaked and front over the place where the pants are all blood-soaked. So it's very obvious that where the blood came from is the stab wound in the hip. And Dr. Bodden's testimony on that makes absolutely no sense. Another thing that makes no sense, that actually disregards what gravity tells you must be true, but what I think what Dr. Lakshmanan told you as well, and he is medically qualified, and that is this. He also said, and this is how he gives you this big time frame, which, by the way, makes no sense all by itself, and I'll talk about that in a minute. He said that there was a period of between 5 to 15 minutes from the time that the neck wound was inflicted to the time that the chest wound was inflicted. And he based that on the very small amount of blood found in the chest cavity on Ron Goldman's right side. Okay? In other words, what he's basically telling you is that blood pressure had so dropped as a result of this jugular wound, he bled out so much that by the time he got stabbed here, it had to be about 10 minutes later, and that's why there's so little blood in the cavity. Okay? But Ron Goldman was lying on his right side and bleeding out so much, you can actually see it in the photographs you'll have back there. There was a tree stump that I think has the number 106 on it. When you have the photographs, look at this, please, because it's blood-soaked. And what they did, before they got the actual reference vials of the victim's blood from the coroner, was they went and they took blood samples from the place where the victims were lying so they would have some idea ahead of time as to what the victim's blood types were. So they took a swatch from the tree stump near Ron, because obviously that was his blood. They also took a swatch from the pool of blood that Ms. Brown was lying in. And that was her reference sample taken from the crime scene. That's how much he was bleeding out. Dr. Bodden doesn't believe in gravity, doesn't believe that that's why he had so little blood in his cavity, doesn't believe that somebody lying on their right side is going to bleed out if he's lying there for a while, and says there's so little blood there, that means he was already near death, and that means the jugular wound had been bleeding for quite a long time, and that's ridiculous. I'll tell you why else. You don't even have to be a doctor to figure this one out. Somebody commits murder, they're going to hang around? What was he doing for 10 minutes? Between the time that he inflicts the jugular cut and the time that he inflicts the chest cavity, if you believe Dr. Bodden, he's got 10 minutes to kill. The door is standing open. There's no evidence of ransacking. There's no evidence of disturbance. What's he doing? Playing solitaire out there? What's he going to... That's ridiculous. What are they asking you to buy? That's why I'm saying, look at the jury instruction. You may disregard any such opinion if you find it to be unreasonable. Ladies and gentlemen, that is one of the most unreasonable things I think I've ever heard any doctor say. That is ridiculous.
Could you slow down just a little?
I'm sorry.